All right, good morning, everybody.
Morning.
I want to call this meeting to order. I'm Kathy Willard. I'm the chairperson of the Fulton County Board of Registration and Elections, and I'm joined here by Dr. Ruth, by Ms. Crawford, and Mr. Johnson to make a quorum. I'm going to ask everybody to turn their cell phones off, including myself. Hang on. And we will not have any public comment at this meeting. We're here to hear challenges to the voter registration of a number of voters registered in Fulton County. Can I ask for an approval of the agenda for this morning?
Motion to approve the agenda.
Second.
Properly moved and seconded. All right, so forgive me, folks, this is my first one of these. Everything that happens to me this month is still a first. But we have a residency.
We still need to vote on it.
Oh,
We just
Thank
made the
you.
motion.
all those in favor of approving the agenda, please say aye.
Aye.
Aye. Any opposed? There are none. The agenda is approved. Thank you so much. So we're here to hear residency challenges against a number of voters registered in Fulton County. According to the law, we've notified people appropriately within the time, and we're holding the meeting within the 10-day window from the notification of the challenge. Both of the people who, well, can I just ask if Ms. Pauline Cupp or Mr. Samuel Ambrose are here for the challenge? The people.
Neither of the challengers are here, and both of them withdrew their challenges this morning.
Okay, I'm not certain that they actually have the opportunity to withdraw the challenges, so we will proceed with the hearing and make our own determination. As you all know, the burden of proving the challenge falls on the challengers, so to initiate this process and not show up for the special called meeting, to me, is an indication that we can move forward in dismissing this or whatever action the board might care to take. And I'm open for comment at this point, if I have not made the appropriate suggestion.
If they've dismissed the challenge, then I think you're correct that it's incumbent upon us to make a decision, even though they've withdrawn their challenge. That's my opinion.
Yeah, and they can submit another challenge at a later time, is my understanding. They do have that opportunity. So.
Yeah, I think that according to the law, and I am not a lawyer, so please correct me, once we've made whatever determination we choose to make, if they disagree with our determination, they can appeal that decision in Superior Court. I don't know if the law addresses whether they're able to come back with the same list and re-challenge. I would think that they would have to challenge our determination first, right, Ms. Ringer? They would have to go to court to challenge our decision on each and every one of these that they would care to bring back. And then whatever the court says we do is how we would handle it. Is that right? Okay.
So just for, Ms. Ringer, just for process, how are these challenges, I can tell you my first thought is that I feel like we're going to do this about every 2 or 3 weeks between now and the November of next year election. I think we're going to get a lot. As you know, there have been several, a few hundred thousand have already been challenged in the state of Georgia. So this is just our first bite at the apple, so to speak. With this process, can any citizen or voter, what's the process for them to be able to even challenge someone? Is it just random, I just go through, pick a list, or?
The law allows any elector to challenge the qualifications of any person applying to the vote.
Charge, it allows them to challenge a person,
Challenge the qualifications.
the qualifications of a person registered to vote. And so these are saying that these people are registered somewhere else.
They're saying that they're no longer qualified to be taking from their, that's what we are taking from their challenge, with the fact that they're relying on the NCOA,
And can you explain what the NCOA
the
is?
National Change of Address List.
And is that something that we use or the state uses?
I'm going to have to refer to Ms. Smith. It's something the state uses, but she can give you more information.
So pursuant to 21-233, the National Change of Address process is a process the Secretary of State's office is allowed to do. What they take the official list of electors and they compare it to the United States Post Office change of address list. And that process actually ran back in 2020. And it's a process, like I said, they compare the elector's address to see if it has changed. If it appears that the address has changed of an elector who has moved to a different address within the county that they are presently registered, the list of electors shall be changed to reflect the new address. And the elector shall be sent a notice of the change by forwardable mail to their old address. If it appears that the elector has moved outside of the county where they are presently registered, they will receive a confirmation notice. And that's the confirmation notices that were sent out. It was a huge chunk back in December 2020. They receive a confirmation notice to their old address. If that elector either they confirm that there has been a change of address, then their status is handled accordingly. If they don't respond within 30 days, then they're moved to an inactive status, which is inactive. In our system, it'll be inactive NCOA. They're placed on a certain clock after that, to where if they don't respond, I don't know for sure exactly the exact moment. I can get it for you, but if they don't respond after they're inactive in a certain amount of time, then they will be canceled in the system. But being changed to inactive doesn't mean you can't vote. We're simply stating that we don't know if you still live here. And since you haven't told us otherwise, we're just gonna, place you in this placeholder of inactive NCOA.
So two things off of what you just said, just for clarity. If someone is moved to inactive and they show up to their polling location and then they begin to vote, they're moved back to active.
Correct.
So they won't, it's kind of like no harm, no foul. It's just
Correct.
a yellow sign next to their name, basically. Secondly, the challengers are using a system that the Secretary of State's office is already using in order to check addresses,
Basically.
seemingly.
Yes.
Okay. I just
Because
wanna-
when we initially got this information, we kind of went through and the list to see exactly what the voter statuses were. And about half of the voter statuses on each list were already in either an active NCOA or an inactive no contact type of status. But the majority of them are inactive NCOA.
Okay, thank you very much.
You're welcome.
So meaning that they are already on the Secretary of State's list to be removed?
Correct.
Okay.
The status is, the process has already started for them.
And so a number of the voters that were that are part of this challenge list were also a part of that, there was overlap on that
Correct.
list. So there seems to be, I think Mr. Johnson brings up a good point, that this is something that will probably be reoccurring, and it's incumbent on us to cross-check those challenges with what the Secretary of State has. And then somehow, I don't know, Ms. Ringer, is it possible to make that known to the challenger?
I
That
believe the
these
challenger,
folks are already on the Secretary of State's list?
I believe the challenger is already aware because they're getting the the same NCOA list that the Secretary of State gets.
There is another mailing that was done on September 23rd. The state sent out, and this is the first time I've heard of this mailing. Eric is a state, it's like 26 states. And they receive information from those states. They mailed out a number of, those confirmation notices to these other voters. We received a list back from the state last night that matched up to the lists that we sent them. And there are 363 that were mailed notices on that Eric cross-check confirmation.
But so
So-
that's going to be a problem in the future in that we had to browbeat the state to get the list that we just got last night. So this 10-day time period that we have, 10 business day time period to hold the hearing, it was barely workable with 373. You may remember when we got the 14,000 name challenge. I don't know how we would be able to get all this work done. So we are going to be trying to talk with staff to figure out how to do this and what we're going to do when we don't get assistance from the state, because it was only because of Rick's continuing to browbeat them that we got anything last night after business closed.
The 40-day clock on the ERIC mailing that they did runs out on November 2nd. And so any voters that are active will be moved to inactive. If any of those voters, I'm unsure if any of them are inactive, if it makes sense that if they are inactive, they would move to canceled if they were on there. But the state indicated that the active would move only to inactive if they're found to be overlapping on here. Now, I think the board, if they have that evidence, I think they can actually, the board probably has the ability just to, and Cheryl would have to confirm this, but would be able to cancel those and remove them from the list if we know that they're out of state. And we just got the list this morning, and they only sent us the voter ID numbers, so we have to run the voter ID numbers on that list against the names and voter ID numbers that were sent to us by the two challengers.
So.
But I don't think we can do anything on these until that process the 40-day clock runs out on November 2nd.
So the state is not required to help us with this? They're not required to give us that information?
Well, I asked them, we asked them, I had Holly start asking our liaison last week, and for the list. We wanted to see the names, the list of people that were mailed confirmation notices, so that we could take the lists that we received from the challengers and match them up against the Fulton list. And they wouldn't give us the list. And then, so finally, they asked us for the lists, and then they said they would run them, do a cross-check against it. So they ran a comparison, and then they sent us the overlap results last night.
But we've already received a list from the Secretary of State's office I thought we received a list from the Secretary of State's office back in August,
Those have all been moved.
and those
So-
have been removed.
So
Okay.
we've done two there have been two mailings so far this year. One is the no contact, those were mailed out by the state, and then those voters were dealt with. And that's an automatic process. If the voters don't respond and the 40-day clock runs out on the no contact, then the state takes action and they move the voters as necessary within ElectionNet. The same thing happens with NCOA. And so we had close to 32,000 voters on the go from active to inactive. That's why our inactive totals jumped up so much. So, but this is a separate mailing that they just did on September 23rd, and that clock runs out November 2nd. And so we don't have that list yet.
Okay, that's
Yeah.
that's a second,
That's a
the
separate,
next.
yeah. So, and
Okay.
I anticipate that they, in advance of the May election, because once we get within 90 days of a federal election, we can't remove voters. So I would anticipate that before that 90 days, they're probably going to do another NCOA mailing at some point, because that's one that they can do pretty easily and check to see who's moved. And hopefully they'll do another one of these ERIC mailings before then as well. And then that may reduce the number of challenges that we get.
Because with the ERIC mailings, they will, after the clock runs out, those folks will be removed.
They will be moved from active to inactive. So they'll still be on our voter registration list, but they'll be inactive That's what the state indicated this morning. So even if they don't respond, if they're active and they don't respond, then they just move over to the inactive column. And at that point, I guess if those names are challenged, then it would be up to the board whether they remove them from the list completely.
And to have them removed, we would have to vote on that, right?
Yes, yeah, and I think also, we would probably, I mean, I think what one of the challengers gave to us didn't really, we don't know how much of this, of what is in here even proves that the person moved out of state. The only thing we would have to go on is that the confirmation notice was just never, the voter never responded to the Eric confirmation notice, for example. And from, I don't think we can be positive on these lists by what is matched, because we don't have, for example, the last 4 digits of the social security number or any sort of, or birth date or anything like that to match against the person that is in another state.
So no,
We basically have the name at that point.
so no identifying information that
Right,
could
we don't
do
have
some
enough
deeper
personal
dive
identifying information really to make
determination.
100% determination on anybody.
Okay.
That's where I would be hesitant to remove someone unless we had, because when we get the mailings from, when they do the felon, they have several different, once the corrections office, or the Department of Corrections sends something to the state, they have multiple layers they can match a person against. And in this case, we aren't getting that luxury to make our determination.
Mr. Barron, I
Johnson?
just want to clarify. So the list in front of the board is not a list that your staff created. This is what the challenger sent to us.
Yes.
And we are saying that we have an issue with trying to verify what they sent.
Okay. Do we normally get lists like this that are done by House districts?
This is the first voter registration challenge hearing this board has had.
Oh.
So I can't speak to anything
Okay.
normal.
Yeah, we had one hearing, I think, back in 2015, but it had to do with people that were, I think, going to be annexed in the South Fulton area. But when they presented evidence, it was all hearsay. And so the board, if I remember right, decided against removing anyone in that. But it didn't have, it wasn't structured the way this is.
And let me just emphasize for the public that might be watching this and paying attention, the burden is on the challenger to prove to us that there's a problem with this voter. It is not up to us to go find birth dates, track people down, do all that. They have to bring us the evidence that makes it clear that there's something we can do beyond what the Secretary of State's already set into motion. Mr. Johnson, did you have something?
So I just want to, based on the conversation you were just having, and one of the issues that I have with this whole process. So I'm going to give you a scenario, and you tell me how likely it is. I have a son who's in college. His name just happens to be Aaron Johnson. He lives he's registered to vote at the house that I'm registered to vote at. Obviously, his birth date is different. Ironically, we were born on the same day, but his birthday is different. It's a different year. He moves. He decides he wants his mail sent to college as opposed to having it here because he's going to be there a little while longer. He's doing an internship. He does a change of address form for Aaron Johnson. Somebody sees that on this list, but they think it's me. So they challenge my residency on this list. Now, is that a possible scenario? Now, granted, they do have to confirm that it's me, but just the mere fact that in this situation, my name can show up on this list when I never even filled out a change of address form, but this person didn't take the time to try to figure that out. They just saw a name and sent it in. So the issue that I have is that we have military people who move, we have college students who still want their registered address to be here in Fulton County, but because they did a change of address for whatever reason, I agree, we need to have multiple layers of reason, rationale other than just on this list.
I totally agree with that, and I think what the Secretary of State has instituted, the use of ERIC, helps to resolve that, because they're looking at data from various places across the various states. I think it's 23 to 26 states. 30, okay, thank you for that. 30 states, so they're looking at not just NCOA, they're looking at a number of data points or data sources to make the determination of whether or not these are people who should very viably, there's sufficient evidence to show that they have indeed moved out of state. I understand your point about a citizen bringing these challenges, and that it is incumbent upon the challenger to present their burden of proof. I will say that I don't know, one of the challengers indicated that they weren't notified about the hearing in time. So I do think that we need to have, since we think that this is gonna be a precedent that we will have these often, that we should be in concert and have discussions with the Secretary of State's office about how to best handle these so that we are in alignment with what the law says.
Can I just take that a step further? One of the things, just given my background, that I've been looking at is, we have a lot of new law, most of which is untested in terms of its actual functionality, and that at some point, we should be working with other counties to bring forward process improvements, because, just so people know, once we get the notification, and it can come under the transom, over the transom, through the front door, however it comes, at that moment, that starts the 10 days from which we have to have a hearing. I want to make it really clear how much I appreciate the staff. Y'all are great. You are in the process of trying to run an election in many jurisdictions, right on top of having to stop and do these things. On top of that, we're all volunteers. We all have jobs. We all have families and other responsibilities to do. I've been on this board for a month. This is my second special called meeting. I doubt it'll be my last one for the month. And I don't mind doing the duty, but I do mind having to listen to things that are not fully baked. And to receive notification in the middle of the night from the challengers that they don't want to come down. Well, that's not on them. They've now started the clock, and we are now responding to that. So again, I want to thank the staff. I want to thank y'all, members of the board, because we all had to mobilize very quickly. We are meeting in this room because one of the challenges we had was to find a room where we could be videotaped and everything, so that we could do what we needed to do to fulfill our part of the law when the other room isn't available to us. So it is not easy to thread the needle on the 10-day clock on top of making the notification once we could figure out where we could even hold the meeting in that time frame. So all that is to say, one of the things I would ask the staff to do is to work with us to think about very, very specific process improvements. In my mind, these challenges should start with the Secretary of State's office. They should be run through. If the Secretary of State determines that all of these people are already on the list, and everybody's cognizant of where they are, and the clock has started on that, then, to me, that's where the buck should stop for every county, and then anything else that needs to flow through as a challenge that isn't currently being addressed through the Secretary of State's process, then becomes something that we need to take action on. Do you see what I'm saying? Now, obviously, they got to agree that that's what they want to do, but, for us to then make a backwards attempt to, retrace the steps is putting a burden on us, right? This is not a burden on the challenger. This is a burden on us. It is time and money spent with our staff to try to get this done. So I am hopeful that we will continue to be mindful of that, and it is my goal by the next session to have a list, even if it's one or two things that we can continue to put forward that will help us make this a smoother process, or otherwise, when we get into the federal elections next year in particular, and we see these challenges come forward, it will make it very difficult to run elections as smoothly as is our intent.
Yeah, well, with the clocks, I mean, we could get multiple ones over days,
That's-
and we could have multiple 10-day clocks.
Yeah. Yeah. It's a very big challenge, but I think we should think through what a solution to that would be. And again, to me, the solution is, it starts in the Secretary of State's office, gets resolved. If people are already on a list for removal or being inactive, then if there is a legitimate challenge that needs to come forward, that has all of the required documentation that would let us make a decision, you know, as you said, you know, a birth date, a social security number, some other indication, because regardless if somebody sends us a list like this, the determination will always be the same. We don't have the information we need to be able to, you know, to remove somebody reliably from the list. So it's almost a fait accompli as to what will happen. But anyway, I just want to make sure that everybody recognizes that this was an extreme amount of effort for naught. And so unless there are further comments, I'll entertain a motion.
Well, the only thing I would add too is that these came in on separate days. So there were two different 10-day clocks with these. So we have already now seen two challenges come in on different days. So that we have to, it may not be as easy in the future to coordinate meetings on the same day for these, and we could end up having them over multiple days.
Well, it would be great if we could have those on our regularly scheduled meetings each month, and they have to arrive by, you know, some date and time prior to the month to give us the 10 days, right? That it, you know, that we have to have it 10 days before our regular scheduled meeting, so that we have those 10 days to do our research and notification, or something that adds some regularness to this and predictability on the timing. So one of the things I'd like us to move to now, so as we don't take any more of anybody's time, is a motion, and I want to make sure that we're very specific about this motion. This is not an acceptance of a withdrawal. I'd like to see us reject the challenge, because the challenger has not shown up, or whatever the appropriate language is. Ms. Ringer, you might want to advise us on that.
That would be sufficient language, deny the challenge or reject the challenge. But again, you have two challenges.
Okay.
That was about to be my question. Do we have to, since we have two agendas, do we have to have two meetings? Or can we
Oh.
deny them together? When I say two meetings, I mean deny it, adjourn, restart, or can we just
No,
deny them together?
I don't think you need to have two meetings.
We can just deny 'em together.
We notified the hearing
Yeah.
today for both
Okay.
of the challenges.
Okay, no,
But
I'm just
I do
making sure
think you
since
should
it's two
take a
different.
vote on each challenge.
On each challenge. So let's start with
Okay.
we got Ms. Cups first, is that correct?
I make a motion that we deny Ms. Cub's challenge.
Is there a second?
I second that.
All those in favor of denying the challenge made by Pauline Cupp, please say aye.
Aye.
Opposed? There are none. That challenge is denied. Second,
What is the name of the other gentleman?
Mr. Ambrose.
Ambrose.
I make a motion to deny the challenges of Mr. Ambrose.
Second.
Properly moved and seconded. All those in favor of denying the challenges by Mr. Ambrose, please say aye.
Aye.
Opposed? There are none. I don't believe there's any other business, so I can take a motion to adjourn.
Motion to adjourn.
Seconded?
All those in favor of adjourning, please say aye.
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 Opposed? Thank you, we're adjourned.
I would love it if we could do that. Have the meetings during our meeting. If there are challenges, handle them during our meeting.